students, teachers, and the generally curious to our seventh episode of the 24-25 season of the Constitution of American Life with Professor Tim Moore from the Center on the Study of the Constitution at the University of Wisconsin, mentor, teacher, and scholar Professor Chris Kavanaugh, who currently resides in Bismarck, North Dakota, scholar and all-around good egg, Dr. James Michael Williams from the University of San Diego, and myself, David Richmond, from the land of Buck Owens. We are more commonly known as the Friends of Publius, or FOPs, and we are excited today to discuss the tension between the Sixth Amendment right to due process and the First Amendment. However, before we get to that topic, it is time to share the FOP question of the day, where we provide a topic that we hope teachers will share with their students, students will share with their colleagues, and their colleagues will share with their grandparents. So today's question is, explain whether or not you agree with the following statement. The importance of transparency in institutions of democracy requires that all judicial proceedings, from criminal trials at the local level to the Supreme Court oral arguments, be televised so that the American public can be aware of and educated on our criminal justice system. You agree or disagree with that? Hopefully that gets you started on a good discussion involving our court system. So, you know, friends, trying to determine, oh, I'm sorry, Professor Moore, you look perplexed.
Yeah, I don't know if I'm going to survive this fall with these opening questions, because these are really good. You can't. All right, let's get on with the program. I mean, oh.
You know, for a man who says he loves liberty, you spend a lot of time telling me I can't. All right, you can't, and you know, I don't know. I get a.
Oh, is it just really good questions and we're not allowed to talk about?
Well, I don't. Do you even have a television?
Yes.
Okay. I didn't know. I know years ago that was probably not.
Well, the question is whether he has the electricity to run it. That's the question.
Well, he's got to chop a lot of wood to get the, get the electricity.
In the shop, they do things a little bit old school.
Is that really what they call it? The Shaw?
Yeah, the Shaw.
The Shaw. Okay. Learn something new. Lifelong learners. That's what I love about being with the FOPs. I learn something new every time we're together. So it's been a week since we last see each other, and I'll tell you, friends, trying to determine the biggest or most significant news story in the world, in a world which moves at the speed of light, is rather daunting. In the last week, since we last had a chat, we've had a presidential debate, a mid-size Ohio community thrust into a constant threat to life, liberty, and property, as well as another alleged assassination attempt on the former president of the United States. However, since we last chatted, I've decided that I think the number one story was the presidential, maybe the first and last presidential debate of this presidential election year. And although it was a week ago, it feels like it was 6 months ago, given everything else that has transpired. But I am wondering, FOPs, what your intellectual, not your emotional, but what your intellectual take on the debate was or is. Mr. Kavanaugh, any insights, thoughts about that debate?
I thought Vice President Harris did a very nice job of baiting the former president to get him to walk into things, and that was actually in a way, it was almost kind of frightening to see how easily manipulated he was by, talking about his rallies and what was happening there. So that's a little disconcerting for someone who wants to be the leader of the free world again, to be able to be sucked into, so easily. So that was a little eye-opening for sure, among other things.
Williams and Moore, let me kind of ask it this way as well. Do these things at all matter, or are they just a source of entertainment these days? Are they fundamental to our political process, do you believe, or really they're just a sideshow in which somebody somewhere is making money, which is the essence of America? Mike?
You kind of changed the question midway through. Do they matter in terms of the election? In terms of the election result, everything I've read and listened to say marginal of best. It's maybe moving 0.5% or percent. Now, in an election that's going to be decided by tens of thousands or 100,000s of people, then yeah, maybe, but usually not. Now, whether the second part of the way you ask it the second time is, I think it has become a fixture of our culture, which is interesting because it's a relatively new way that we kind of test our candidates. So I think if candidates were to not have debates at this stage in American history, I think the public would find it, they'd be flabbergasted that they weren't up there to do their thing.
But if they did a Lincoln Douglas style debate, a real debate, if they did true policy debate, people would turn the channel in 15 minutes.
Yeah, I think you're right. And I don't think we have the candidates these days who could do what Lincoln and Douglas did. Seriously, I don't think they have the depth of knowledge or the stamina. But my only other take on it was that I understand why the journalists keep asking for policies, and I understand why the American people keep saying, I want to know what they're going to do. But for those of us that are doing this curriculum, studying this, we know that it doesn't work that way. The president doesn't walk in and say, I want this policy, and it gets done. So I'm persuaded by the takes on this. These are not mine. These are things I read or listened to. I think questions about what's your decision-making process? Or who do you want to have around you in the room? Or I think at one point, former President Trump talked about firing people. That would have been a good follow-up. What's the basis of which you do fire people? I think those types of things, for the people to get a sense of how they're going to work a room like that is more important. And so maybe Chris's point is a good one that I think we saw a lot about how the different candidates handle a little bit of pressure and a little bit of baiting. And even though that was very performative and it was very much, she walked into the room, that being her strategy, I think it was revealing to those temperament issues that I think are more important than the policy ones.
Professor Moore?
I only watched about 7 minutes of it. Don't tell anybody. I guess my response was I generally don't like being yelled at. So I hung in there for as long as I could, and yeah, I'm speaking totally ignorantly, which is kind of par for the course most days. But I just my response was I don't want to be yelled at. Well, I think maybe that's just kind of maybe I'm saying the same thing. The revelation of temperament, at least when the camera's on. I don't know. Maybe Kamala I imagine she can get angry too. But I think Mike's point there about revealing the temperament piece, and Chris mentioned that too. But so I hung in there for 7 minutes.
Good job. And that's just between you, the three of us, and the dozens of people who will be watching this segment.
We don't have millions, huh?
No, we haven't reached that level yet.
It's interesting you say you don't like being yelled at, yet this friendship has lasted a long time, since that's what we tend to do with each other when we're off camera. It's just yell at each other.
Well, but we know each other, and we can get a little worked up towards each other, but that there's a thick relationship here. I don't mind that at all.
You don't have a thick relationship with presidential candidates. I understand that.
No.
Okay.
No.
You don't want to have a beer with either one?
No.
Isn't that the standard? Isn't that the standard since George W. Bush or
I think
Bill
so.
Clinton?
Yeah.
I want a President Rock and have a beer. Sit down and have a beer with him.
I think that's going back to the old era of the common man, right? That's the way we say that these days. Is you want to have a beer with somebody? It's kind of like going back to the common man.
I can see Andrew Jackson maybe saying, no, I think he despised people. Well, no, I guess he did have big block of cheese day or something like that. But I have FDR. Can you imagine FDR saying that or being that guy?
I,
Um,
I
Mike?
just, I'm sorry, this is whatever, I'm gonna say it. So I just finished the book y'all have been talking about, Unruly Americans. I just finished that book this weekend, and it made me think of the flip side. Like, how many politicians back in those days would want to have drinks with their constituents? Because a lot of those people were really upset with a lot of things going on.
Yeah.
There's
Good point.
there's a great in the movie Lincoln, which is based upon Doris Kearns Goodwin, excellent book, Team of Rivals. There's a scene where early in the movie they're debating, about whether to push the 13th Amendment, and Seward is Lincoln, and they're going back and forth, and there's a couple come in from Kentucky, and they want the president to take action because some reason I think they lost control of a toll road or something like that. And so, and to carry out his point, Seward asked these people about, would you be in favor of an amendment abolishing slavery? And he explains it to them. And of course, he's doing this to make a point with Lincoln. And they said some nice things. And then he finally just lays it out, would you or would you not? And they say some things. And of course, I'm not going to repeat some of the language that you might have heard in 1865. But Seward turns around and looks at Lincoln and he goes, the people.
Hmm.
It's, I mean, it's really subtle, but it's like, yeah, I'm not sure those guys want to have, would certain politicians today want to have drinks with their constituents?
Only if they were donating $150,000, maybe. I'm
You know,
sorry.
that's an interesting point, Chris, because it reminds me, I saw something that J.D. Vance said over the weekend. He has this framework. I don't know enough to know to evaluate it enough because it's modern politics. But he said, American politics is between East Coast elites and Southern elites, and the hillbillies are the determining factor as to which of the. He's talking historically, and the hillbillies, whoever they side with, kind of wins. I thought that was an interesting. To your point about populist versus elites, Chris.
Well, I saw that,
the
but that's not exactly,
the courting of the common man
that's not
cuts.
that's not exactly what he was saying. He was laying out the comparison today
Right.
to the Civil War.
Right.
And the East Coast, West Coast elites are the Northerners, and he talks about the Southern Bourbons, and that so he's talking about that being the hillbilly. So in essence, what he's trying to say is his side would be the defenders of slavery, and the East and West Coast elites would be the ones that would want to see slavery abolished. I mean, to complete his analogy, which was, if that's where you want to go with it.
Well, that went in a direction I didn't think would happen, but that was enlightening. I enjoyed that. So we need to move on, gentlemen, here. Today's episode is taken from the We the People State Questions, Unit 5, Question 3, and asks us to discuss the tension between due process rights found in the Sixth Amendment and the individual and institutional rights found in the First Amendment in varying circumstances. So let's begin our discussion with Professor Tim Moore. Tim, to the best of your knowledge, were the founders, framers aware of the alleged tension between these two rights in the 18th century? And I guess more specifically, was there like evidence, examples, illustrations of this in the second half of the 18th century that they might have, referenced as they're thinking about designing rights here? And and I don't know if they wanted tension between these rights or it was just a natural thing. What are your thoughts?
Well, it seems to me that there's two. The short answer is there's no way they could have configured these modern tensions at all. But what they did consider is, and this is an inheritance from the British system, British tradition. They inherit. They're keenly aware of the importance of trials, jury trials. In fact, in our studies during the ratification, jury trials comes up an unbelievable amount of time in the ratification debates. So, and that's an inheritance from the British tradition that jury trials, and so there's two basic concepts that they really really are fixated on, and one is this idea of vicinage and peers. So they don't use they don't talk about public trials very much, but they do in a way when they talk about trials in the locale where the crime committed. There is a commitment to local knowledge. Now, are there newspapers reporting on trials? Occasionally, but the public knowledge of a trial is kind of embedded in their commitment to local vicinage trials, and the issue of peers. So I think those principles are the closest we get to any of these kinds of issues, these modern issues of coverage, public awareness of trials. I mean, it's some of this too about the public trial piece is rooted in this. I mean, in the mid 1600s, there was a lot of constitutional changes that took place in England. And significantly to this point that we're talking about today is the abolition of the Star Chamber, where originally it was a kind of an ecclesiastical court to get to the truth of heresy. Let's put it generously. There was no comfy chair involved in the Star Chamber. So the abolition of the Star Chamber in the 1640s, I think, really is embedded in this colonial and revolutionary mindset of the publicness, the need for a publicness of trial. So I think those two things, vicinage and peers, kind of gets the closest we can to these modern issues. I mean, there were a couple of charters early that mentioned, I think, that used the word public, but not really until much later does that word appear in I think it's Vermont that has New Hampshire and Massachusetts have the longest descriptions of how these jury trials would work and how public they would be. It is interesting in the Declaration of Independence. One of the grievances is the fact, and this comes out of the 1760s, where admiralty courts, where trials took place somewhere away from local and away from peers, largely because the Crown couldn't get any convictions. But so I think there's some real to make it a clean connection to the modern is a stretch, but I think there's embedded in those two principles, there is some serious consideration in vicinage and peers that they would be public.
I don't
And
know.
so reliance on local public knowledge of the proceedings of the court.
Well, I don't know. Did you ever, in thinking and preparing for this discussion, I watched one of the segments in the John Adams series from HBO there, and it's the
Yeah.
one where the trial of the Boston Massacre. British.
Yeah.
Is that, and to the best of your knowledge, is that accurate as far as
I don't know. I've never seen that series. Again, I
Well,
don't have electricity to run my TV. But I mean, I'm glad you raised that, David, because there's another trial that's very important in colonial America too, and that's the Zenger trial. So I would urge students, and we'll put this in the resources. There's actually two interviews I'm thinking of with John Kaminsky, my boss, where he lays out in classic Kaminsky fashion, weaves a great tale in getting to these historical trials. And so yeah, the Boston Massacre trial, it's a remarkable trial in a sense, because you would think it would go a certain way, and it didn't. And John Adams was involved in that. So I would say the Zenger and the Boston Massacre are trials worth looking at if you want to dig deep into this colonial revolutionary era.
I just found it fascinating, by 1791, we get the Sixth Amendment and things, yet looking at this trial. And Chris, I'm assuming you've seen the series.
Yes.
And what do you think? Because I'm thinking about, the witnesses are actually standing amongst the community members as they are, and this guy's got, people breathing down his neck, like, be careful what you say. you've got, I mean, that's just the intimidation factor. All right, going
Well,
on. So I'm just wondering, is that accurate or was that Hollywood?
no, I think that's accurate because those people are not allowed past the bar, so to speak.
Yeah.
So they're on the other side of the bar. And the other thing for the students, the idea is during the colonial period, we tend to think of like, you can have character witnesses, but if you're talking about a witness, being involved in the trial, they wanted back to the Tim used the word vicinage, and students, what you get is the word vicinity, tried in the vicinity where the crime was committed, where the maybe took place. So part of that deal is like you want witnesses that know people. You want to know people that go on the stand. You have an idea of their veracity or not. If they're good witnesses, and now it's completely opposite of that. So, but yeah, it's fairly accurate. And also students in that John Peter Zinger trial understand that's more about jury nullification than it is about free
Yep.
press. It gets talked about in terms of free press, but it really is more about the early jury nullification. But an excellent trial, as Tim said, to take a look at.
There's one more. I can't help but get into the anti-federalists here just a little bit.
Shocking.
There was great suspicion on the part of the anti-federalists about the federal courts as they saw it proposed in the Constitution. They were suspicious that the Congress would not create inferior courts, and to this idea of vicinage, that Farmer Joe would be drug off, because as we know, the Constitution only provides for one federal court and inferior courts if Congress deems them necessary. So the anti-federalists ran that out and said, wow, potentially there's going to be no federal courts. And so you talk about being taken away from where a case is emanating from. They hearkened that back to the admiralty courts. So there's this deeply rooted commitment to vicinity in the American colonial revolutionary experience.
So, Tim, you point out that, again, probably local newspapers didn't cover to the same degree that we might be thinking of in today's world. I am wondering, and this is for anybody here, at what point does this tension, all right, and I'm looking kind of before technology, all right, because we want to get into the changing technology and how that might change the relationship. But I'm wondering, just before technology, 19th century, early 20th century, is there rising tension between Sixth Amendment and freedom of the press?
1807.
Help me out.
Some guy, Burr was his name. I don't know. Burr was in trouble, and then some other guy, Marshall, was presiding in his thing, and Burr's attorneys are, because newspapers were covering this because it was a big deal, and so they're like, okay, they wanted Marshall to exclude the jurors with knowledge or opinions because they've been swayed by the media. And Marshall lays out, and I'll put something in the show notes for this, but Marshall lays out, what kind of knowledge people can have, and that's kind of the basis that's going to be followed for about 150 years. So in 1807, early on, Aaron Burr's, doing some stuff that probably shouldn't have been doing, and he gets in trouble for it. I mean, holy cow! I mean, you even have a sitting president has to give a deposition.
Yeah.
So that's a pretty big deal.
Who would have ever thought that, right? It's interesting. Your question, David, is interesting because I've been reading an inordinate amount of newspapers from the late 80s through 80s and 90s.
Thank you.
And it's interesting to me, there are all kind of advertisements in these newspapers at the time. Well, it's so fascinating. There's two kinds of advertisements that are quite remarkable to me. One kind is where the husband is putting an ad in a local newspaper, and he's basically saying, if this woman, my wife, is going around town, don't let her charge, basically don't let her run up my credit card. Don't let her charge on my account. She has left my bed and board. It's quite a phrase that appears in a lot of these ads. And so the point is, they're not going to a local magistrate and saying, they're not, they're not using what we're very formalized in our legal proceedings now. And another kind is runaway slaves. Report to me. It's not report to the magistrates. And that's an interesting thing, because in British history, now this goes way back, there were such things as, they were called private prosecutions. They didn't rely on a formalized court system. These were like private prosecutions where it was independent of courts and juries. Now, that's a long time ago, and that eventually the king kind of comes along and starts to standardize that, where there will be public prosecutions. And I think that really pushes the desire for public trials. But it's interesting to see these private type dynamics even in the colonial and even post constitutional era, where these private prosecutions, there's still some vestiges of that. And that's really bizarre.
So, Professor Kavanaugh, and I guess part of me would like to get into the evolution. I don't know if we have time, but no doubt the tension between the Sixth and the First, to me, seems to have arisen in the last 100 years as technology has improved and increased. So do you agree with many, and I read a lot this week, that exponential growth of communications through technology has significantly undermined the ability to receive a fair trial in this country and in most jurisdictions? And I have a follow-up to that, but let's just deal with that. Do you think the increase in technology undermines?
It's probably made it a little more difficult, but my goodness, I mean, how many different, we're familiar with U.S. history a little bit, and how many crimes of the centuries have there been? Trials of the century. I think of Scopes, going back to the Scopes monkey trial out of Tennessee. That was in the 1920s. So that was 100 years ago. And so radio was the medium of the day, the mass media of the day. And of course, people flocked to this small town in Tennessee to watch two legal heavyweights duke it out. I mean, you have Clarence Darrow for the defense, and you have a special prosecutor, William Jennings Bryan, brought in. Does that keep Scopes from getting a fair trial? I'm not sure. It's interesting.
Well, I don't know. Yeah.
I'm sorry.
I guess I think possibly a better example is the trial of the Limburg kidnapping.
Yeah.
Yeah.
Sacco and Vanzetti too in the same time frame. Yeah.
Right. That I'm just wondering, the pre-trial publicity as well as the trial was so heavy-handed, and so I am wondering, and that was before the modern sense of technology. You had radio, obviously, and newspapers. So again, this premise that and again, I should have cited where I got that from. This premise that Sixth Amendment right to fair trial is being eroded because of technology. All right. And the ability of the mass public to put pressure on the system, and maybe that's not exactly accurate. Now that I think about that,
I don't think that it is, honestly, because, well, first of all, let's deal with the reality of the situation. What do we have? Like, at a conservative estimate, you have 90% of federal cases do not go to trial. 95% of state cases do not go to trial. And those are conservative. And some would argue that only 2 to 3% actually go to trial. So that in of itself, so students, check my sources on that, but I think you'll find that's pretty legit. So we're talking about a very, very, very small percentage in the criminal justice system actually go to trial. And I think that the court has traditionally, through case law, I don't say erred, but this public's need to know, right? It's very interesting to say, and Tim alluded to this, honestly, when he was in his first response. This goes back to this idea that the public needs to know. Doesn't mean that the press necessarily has a right to print prior But when judges have tried attempting some prior restraint going in, they've been slapped down by the Supreme Court. So there's this tension between our desire to know for it to be public, going all the way back to the Star Chamber, as Tim mentioned, up through the Admiralty courts, and local people wanting to know what's happening in the local judicial system. But it's more of a right, public's right to know, not necessarily a media's ability to publish that information. And we know that there are cases where, I mean, that judges can do things to eliminate that from their, you know, the whole list of things that they can do in terms of like change of venue. They can issue continuances. They can a gag rule. Hello, I mean, we're living with that right now for people being involved in cases. The no comment rule, or the voir dire, going through voir dire and jury selection, and sequestering the jury or giving jury instructions. I mean, there's a whole list of things that judges can do to make sure that trial is more fair.
Should that extend, I'm wondering, this is kind of my second question, should that extend to the families of victims of crime? Should a judge be able to put a gag on the family members? Let's say they want to start posting stuff to social media that could influence, especially in smaller or mid-sized communities, where
Sure.
that could poison the jury pool
And
there, or even in the jury room, wearing T-shirts or whatever.
well, I posted some information. I will post a great case called Casey versus Musaladin. I'm not sure if I'm pronouncing that last name right, from 2006. And I found out about this case, boy, a friend of ours, Troy Hamilton, Troy Money Hamilton, is the first guy to turn me on to this. And it really involves the family members sitting in the front row wearing a button of the deceased. And this guy's on trial for murdering the deceased, right? So this is a capital case. And the argument that his lawyer is going to make on appeal is that that hurts their First Amendment right to wear that button. And they talked about the size of the button. Was it visible to the jury panel? Yada yada, all those things. And the argument for the defense was you have the right to confront witnesses against you, and there's no way for them to confront that witness on the button. And I think the Ninth Circuit or 11th Circuit, I have to go back and take a look, agreed. They reversed the lower court opinion, and they found for the defendant, went to the Supreme Court, and the Supreme Court slapped them down 9-0, saying, no, they have that First Amendment right to wear that button. So that's an interesting in terms of the family. Now, you know, judges are going to have to take this into account when they go through voir dire. They're going to have to be able to, you know, interview prospective jury members, and you know, you hope that those people are honest in their assessment, what they're paying attention to. But you know, can that sway? Yeah, probably could. But the family members have the right to publish and post things.
Yeah.
But I'm not sure that it's really interesting. I think because the more I was reading about this, it's just that idea of the public's right to know versus your fair trial, and not necessarily free press. So it's a tough one, I think.
Yeah, I'm sorry. I'm just thinking about you mentioned Troy Money Hamilton, and I'm just wondering, is there a kickback involved with you mentioning his name here on the program?
Oh goodness, no.
Just knowing money is what I do. I'm just wondering there. Mike, you were wanting to jump in?
Yeah, I think I have just two questions for you and for the students. A legal one and a cultural one. So the legal one is, my reading of the Sixth Amendment is that your right to a fair trial kicks in once prosecution begins. So what happens in the investigation stage, which I think could matter, right, for a community, that's not covered by the Sixth Amendment. So that's just kind of a question. I think that's right from my law school days. I think that all the press that comes out of the person of interest, you know, who we're supposed to be assuming is innocent until proven guilty, that may have an effect on a community. It may affect what Chris said about a defendant deciding whether to go to a jury trial or not. and instead just take a plea deal, which there are many reasons plea deals happen. So, and then, so my cultural question is, Dave, you were asking about just technology on its own, and I kind of agree with your assumption that it has made it harder. But then there's something cultural going on as well. This intersection of, I think, news and entertainment has changed so much the last 30 to 40 years. Not that it hasn't always been there, but I think it's changed a lot. And the profit motive of these news organizations, where to keep eyeballs, trials and the drama around trials are a wonderful way to keep people watching and then watching their commercials, which is how they make the money. So I know that profit and this line between entertainment and news has always been there, but it seems like it's really kind of exploded. And maybe that's partly because, David, your point about technology, maybe those two forces are kind of feeding into each other.
I think it's a wonderful insight because I came across a source that it had a couple of, I thought, fascinating. One, if we look at the most popular genre of podcasts is true crime.
Yep.
All right. One of the most popular forms of television, all right, is crime stories, real crime stories. And television, especially with this explosion of the variety that we have. But I mean, I'm trying to remember the ABC program 2020 or whatever, but that's pretty much committed now. It's not a variety of shows, it's all crime, true crime. So I think that's a wonderful insight as far as our culture and the monetization. Yeah, I'll get that word. Making money off of that culturally has become a real key factor. And I think this delicate balance there. Yeah, Chris.
I just want to go back. There's a case called Nebraska Press Association versus Stewart, and it goes back to a 1975 case. This guy, Edwin Charles Samantz, was arrested for murdering 6 family members, including children, and was in Nebraska. And of course, you have such a horrendous, heinous act. It's going to get tons of pretrial publicity. And the judge issued a court order with it prohibited any reporting of his statements that he may have made to the police or others, including what had already been presented as evidence in the pretrial hearings. So the Nebraska news agency said, well, wait a minute, again, our right to know, right, versus his ability to have this fair trial. And this gag order, we believe, violated our right to know. And the Supreme Court agreed. And I think they said that pretrial publicity, even the stuff that's really going to sway it against the defendant, does not necessarily lead to an unfair trial. So, I mean, even on that pretrial stuff, the court has tended to side with the media.
Well, let's get into the actual trial, Mike. And I may be wrong here, but I believe that the leading case that attempts to carve out a compromise between the right of the defendant to a fair trial and the right of the public to have access to information about this is Sheppard versus Maxwell in 1966. It's actually not that these students might know it, but it actually leads to the creation of a television show and then a movie called The Fugitive here on Dr. Sheppard, I believe it is. But can you talk a little bit about that decision and the guidelines that the Supreme Court provided trial judges with regarding press coverage of criminal trials?
Yeah, I have a lot to say here, but I'll try to keep it narrow and then we can see where it goes. This is a fascinating case, and I don't remember reading this case in law school. Maybe I did and just completely forgot it. But so students, it's a case. It's decided in 1966, and it is still the precedent. So it hasn't been overturned. It's the precedent about how judges are supposed to manage this. The case itself is fascinating. 1954, 4th of July, Dr. Sheppard goes out, says he falls asleep on his couch. He wakes up hearing commotion upstairs. An assailant is beating up his wife. His wife is dead. He chases the assailant outside and fights with him, and then he gets knocked unconscious. His child upstairs was never hurt. And immediately the investigators thought that maybe Dr. Sheppard wasn't just a bystander, that maybe he had something to do with the killing of his wife. So he's tried for this, and this is where it gets interesting, because in 1966, Sheppard has already served 10 years, and the Supreme Court decides that he was not his Sixth Amendment rights were violated, and he has to be retried. And when he's retried, he's acquitted. Okay. And this court decided this case 8-1, and Justice Clark just goes after this judge and goes after what happened in the courtroom, saying it was like a Roman holiday. There were way too many press there. The judge didn't keep control over what the press could hear in these sidebar conversations, and that it all added up to the rights of the defendant being violated. So what the court basically says is it kind of admonishes this judge and says, you have to do a better job of keeping your courtroom open to the press, but there has to be some limits. So the limits could be gag orders. It could be limiting the number of press. It could be checking the credentials of the press. It could be sequestering the jury. And from what I could tell, the subsequent cases have just used Sheppard in this balancing act of trying to balance how the First Amendment and Sixth Amendment rights are going to unfold. And sometimes the cases go of the way of the defendant. I think in most cases, the cases go of the way of the First Amendment, and the press, and we could talk more about that. What I did find interesting is it's a live question amongst the circuits right now of what the standard should be for gag orders, which is probably the most stringent restriction a judge can put on the media, right? Where basically, or put on people involved in the trial. You can't talk to the media. Some circuits say that you only can do it when there's a clear and present danger that the defendant is not going to have a fair trial. And other circuits say it just has to be a reasonable suspicion that it's going to be. So even this decision is down in the circuits, and different judges are applying different standards.
Well, explain this to me. I don't understand this. Why don't we just have an automatic gag order, once the person is arraigned, and again, sorry, but anybody involved in this case, there is no speaking to the press, especially given how information flows today and how easy it is to poison a jury pool. So tell me what you think about that. I just why can't we do just an automatic gag order?
Well, I think some of the short answers to this is the court could have put that in this decision as a guideline. They're allowing courts to do this balancing act. And so your question is, okay, why are we even allowing for this balancing act? A lot of countries don't. And I think that speaks to, shocking, I think it speaks to our culture. And I think it speaks to this idea of the First Amendment and the power of the press, that I think judges are very careful of doing that. I don't have a better answer than that. I think another way you could do this is you could just, well, it gets at a different problem, but you could sequester the jury. If you're worried about the jury getting information, I read this one judge said, except for the lack of violence and brutality, being sequestered is like being in a medium security prison. So judges don't like to do it that often, right? So you could do these things, but I just don't think I don't have a better answer than I just don't think it's in the culture right now to do it.
Well, one of the links I'll provide in the resources, you'll see judges that have tried this at the local level. And then as it gets appealed in terms of doing exactly what Mike's talking about, trying to live what you're talking about, David. So trying to limit the press influence early on, they just get slapped down by the Supreme Court in various cases. And so it becomes why am I going to set myself to be beat up here by a court above me by trying to do this? So.
Yeah, good point. So Tim, since I think one of the key elements here, and especially, I don't know if it's since the age of Reagan and the so-called explosion in crime. I guess it was the 60s and 70s, and then there was a lot of pushback, and I would argue some draconian laws to fight crime in the 80s. But since the early 80s, around 33 states have created victims' bills of rights, which some
Yeah.
legal thinkers believe brings an imbalance to the system of justice that was designed to protect the rights of the accused and to guarantee as humanly possible that no innocent person is falsely imprisoned. What are your thoughts of rights for victims in the criminal process here? Does it create an imbalance?
Um, well, some people, I will put some of this in the notes. I mean, I think it's interesting you prefaced, embedded in your question is kind of a, gee, where's ground zero on this movement? And I think you're right from what I've read. It seems to be in the late 70s, and there was a task force in 82. I think Reagan had a task force. It was labeled the I know it was a task force. And there was a series of laws passed at the national level in the 80s as well, getting to this under this framework of that the victims of crimes, especially violent crimes, deserve rights. In the 90s, a lot of the states really kicked in. So there was a precipitous change in the late 70s, early 80s. And one of the things I read was quite interesting, that that is not so much a legal shift that occurred within the legal system. From what I've gathered, a lot of the commentary, and this gets to your point about is this a good thing or a bad thing, is post-World War II through the late 70s, there was a tremendous emphasis on rights of the accused, the assumption that you protected their rights with the hope of rehabilitation. So in many ways, the one thought is that emphasis overemphasized and excluded the victims. There was an emphasis on the individual and the accused. And so the thought is that with the rise of victims' rights, there's been a shift from more of a liberal emphasis on rights of the accused and rehabilitation and all possible fairness to a more conservative view that justice needs to be done. So a kind of a crime control framework rather than a mediation framework. So the shift to victims' rights culturally is in some ways a cultural shift. And I find that fascinating. There's an interesting article that we'll put in the notes by Lynn Henderson, where this argument is laid out, that victims' rights movement emanates from the 80s. Now, obviously, a lot of the victim rights, there's a lot of laws on the books, like to your point. I didn't know there were 33. But everybody seems to say, yeah, well, it's on the books, but enforcement is a real problem here. Is where it breaks down. But there's a lot of really interesting, I mean, sentencing guidelines is another thing that is kind of within this framework of, we're not going to trust judges in this rehabilitation model. We want, and the argument is clear sentencing guidelines with no wiggle room for judges, to let those dirty bastards off the hook, So there's a lot embedded in this victims' rights movement that I found it absolutely fascinating to look into this movement since the early 80s.
Well, if we dabble a little bit in originalism, I guess here's my struggle. If this would have been something that concerned the framers, the writers of the Constitution, there would be language in the Constitution somewhere about, all right, that the judicial process must, consider the families of victims or this victim, but that's not their concern at all.
Well, I think a civil tort, I think that was around at the founding too.
Right.
I think tort and fines was the way they addressed victims' right at that point. And they would not use that terminology, but I think it's maybe embedded there.
Okay, Chris?
Well, along with libel, I would go back to the concept of libel as well in the colonial period. But I'm just curious. I just am listening to Tim talk about victims' rights, and I know many of these take on the names of victims right? Of people that maybe have,
Marcy's Law. Yeah.
yeah, I've heard, so these allow families, right, to make statements.
Victim
Now,
impact. Victim
the
impact.
impact statements, and so these come before sentencing most of the times, does it not?
Yes.
So you had a person that's gone through the process, uh, and jury's reaches verdict and guilty. That's when you would probably have the families be able to give that statement, that impact statement. I'm really curious as to how those impact statements affect sentencing.
Yeah, a couple things I looked at today. It's interesting. I mean, I went way down a rabbit hole on this, and it's really bizarre to me because this is all after 1800, and so I was quite intrigued by this. But yeah, the victim impact statement is interesting. And again, here's my opinion on this based on some things I've read. It seems to me that we live in a very therapeutic culture. I mean, this is to Mike's point over and over and over again. Hey, we got to look at culture. What's going on in culture? What's going on in culture? I think the theory behind victims' impact statements, it seems to me to be healing and recovery and wholeness. So I think including impact statements is kind of a therapeutic framework. That this is going to help the family recover from this traumatic event in being able to articulate clearly how they've been affected. Now, there's a lot of evidence that it perpetuates the victimization rather than them being able to face it straight on and recover to some degree. So there's a lot of debate about whether these actually do function in the way they were envisioned. But yeah, I'm glad you raised that issue of victim impact statements because I think it's a part of the whole victims' rights movement.
I see it more of the tail end of get the war on crime, right? The idea that it goes back to the mandatory minimums, the sentencing. So I see it also part of that way. A certain court, the Warren Court, perhaps went one way in establishing the rights of the accused and maybe extending those. And now we get into the 80s and we're going to get tough on crime. And oh yeah, we're not going to forget about the victims here either.
Right.
I'm not saying this. I'm not casting aspersions.
No, that's what some are saying, that it is a definite swing to a more conservative individual responsibility punishment framework rather than the old liberal rehabilitation framework. Yeah.
Mike, were you going to jump in?
Yeah, let me just say that I do remember this debate. I was in law school in the early 90s. And this was really, there was a lot of conversation on this. And there was a lot of conversation just about even the narrative, how it was framed, Tim, a victim's bill of rights, right? Yeah. And kind of this like putting on the same sort of level of what the rights we're discussing in the Sixth Amendment, which I had a lot of professors who just were, no matter how they felt about victims' rights, it bothered them that this discourse was happening, saying that the two somehow had equal weight in the trial process, given what's in the Sixth Amendment. So,
well, and I guess my struggle with it again goes back to maybe it too simple of a perspective that the focus of the Constitution is on the rights of accused. And that if we get to Blackstone, one of the greatest sins can be putting innocent people, falsely accusing them and putting them behind bars. And the understanding that the individual versus the state is already a tremendous imbalance of power. Adding now to that equation victims' rights, and you have a whole cottage industry that has developed around this concept of victims' rights, which now has economic resources to even further imbalance. And I think we need to be very honest here, that in this situation, which is already, there is a social economic dynamic here, that a lot of the people accused of crimes come from lower economic groups. And they don't have the resources to fight back against large organizations that may be going after them. And that's what I guess bothers me a little bit about that. And you see, especially some of the well-known victims' rights getting out there and lobbying for death penalty or whatever tend to come from, predominantly white and predominantly upper middle class communities. And it just further, I think, intensifies the imbalance of justice that we've always faced in our society. I guess
I think your point's well taken, David, because I compare MAD, Mothers Against Drunk Driving, versus so many, like in Milwaukee, there's just it's just a plague of crime, and lower socioeconomic groups suffer the brunt of much of that. And when you compare the outrage, when I mean, who amongst us would take exception to a mother that's lost her son or daughter to a drunk driver? I mean, the visceral emotional response, but then this disconnect between, mothers in lower socioeconomic circumstances that lost their sons to senseless gun violence on a street corner. It just, I mean, those are horrifically awful things, but to your point, there seems to be a disproportionate concern, outrage. I'm not sure what the word would be there, if it's upper middle class white families that want to tap into the victims' rights tradition.
I just want to go back for a second to Mike's point about being in law school, and this whole idea is this victims' bill of rights, that we have the Sixth Amendment, and it's pretty clear what it says in the Sixth Amendment. And I'm going to share on the show notes a law review article, and it's interesting because it goes back to the language I was using about the public's right to know. And where do we see that embedded within the Constitution or the Bill of Rights? We don't. The same thing is true with these victims' bills of rights. We don't see them, but we have this whole idea that because of culture, we have this belief, we have this right to know, or now we have organizations, David, as you alluded to, that are, and this sounds bad because I'm hearing these words come out of my mouth and going, well, yeah, victims somehow should have a voice, but the idea that we're putting it on par with the Sixth Amendment to the United States Constitution, our need to know, our right to know, or victims' rights, that is a little troubling.
So, Chris, speaking about troubling, I think something that's fairly, I know it's not recent, I know this is, it's at least the last, 100, 150 years. One group that I think that doesn't get quite the attention when we look at the impact of media and the impact of, both pretrial and trial media coverage are jurors. And especially with today's method, social media and things like that, I think, and let's be honest, the Trump cases, the jurors on the Trump cases, I know in one case specifically, because there was reporting, were petrified that their names were going to be put out into the public, and they would have to face what so many people in this country have to face is the mob anger. All right. If they're on the jury and that jury were to find, the defendant guilty or liable or whatever there. So I'm wondering that if I'm called on as a juror on a major criminal case that has sparked tremendous emotions on both sides of the issue, should I be guaranteed anonymity? Should there be a process in which I'm guaranteed anonymity before, during, and after trial?
Well, I think, first of all, dealing with one of the Trump cases, I think the judge told the folks after they were dismissed from the jury that you probably want to preserve that anonymity. And I think that also goes to one of the gag orders against former President Trump that would prohibit him from disclosing that, because part of the defense is, for your legal team to be able to put on a vigorous defense, they need to know the names and information about the juries, especially when you're going through voir dire. And the students, you guys will learn this is seating of the jury and paneling a jury, and the defense can disqualify a certain number, the prosecution can disqualify. So how can we impanel a jury? So the defense has to know that, but can be gag orders put in place so that information could not be disclosed. The first truly anonymous jury I could find was actually 1977, United States versus Barnes, and organized crime, selling drugs. Yeah. So I mean, if I knew that I was going to be on a panel and I'm going to be interviewed, whether or not I'm going to be sitting on this jury, and I know full well who the defendants are, and these are people that have strong links to organized crime, they've been weapons and cocaine charges. I'm probably going to do everything I possibly can to be an idiot when I'm being interviewed so I don't have to be on that jury, because there would be a fear for my life. And the court agreed that in that case, yeah, there are times when juries should be anonymous. Involvement in organized crime, the defendant's participation in a group with the capacity to harm the jurors. If the defendant's past attempts to interfere with the judicial process, this may be ringing a bell, I don't know. The potential that if convicted, the defendant will suffer a lengthy incarceration and substantial monetary penalties, right? So there's a list, and I'll put this in the show notes, of when judges can make juries anonymous. And then on a different side note, if for anybody paying attention to what Mexico is doing right now with their judicial reform, one of the things they're allowing for, I don't know if you guys saw this, and I'll put an article again in the show notes about this, they're allowing judges to wear masks. So judges can remain anonymous for fear of the cartels, or allegedly, for anybody that's listening, allegedly fear of the cartels. So that's way different than anonymous juries. But there are times when, again, starting in the mid-70s, where the court has said, yeah, you know what? We may need to do that to protect the jurors. Because if you think about this whole concept of a jury trial, and Tim alluded to this, it's one of the rights embedded in the Constitution, Article 3. You have the right to a jury trial, all the way back to Magna Carta. This is really, really one of the most important things in terms of the length of time. That's an important right, is the idea of a jury trial. And we're trying to maintain a level playing field if we can. And so there may be a time that to maintain that level playing field, or actually to get 12, average citizens impaneled on a jury, we may have to do things that doesn't really open up to the public's knowledge.
So, Mike, again, this is, to me, this is an issue. This balance, the right to a fair trial. It's really an issue that plagues our society, and especially, I think the trials of former President Donald Trump has really brought this to the forefront on what fair trial means in our society, kind of thing. So, but I don't know if it's it is particular to the American legal scene, or do you see this kind of strain, tension, struggle to balance in other democratic societies around the world?
Yeah, I mean, I kind of looked specifically at Europe and then Australia, Canada, just to kind of see what was out there. Most of those countries, all the countries except for United Kingdom that doesn't have a written constitution, right? There is a right to a fair trial, much like the Sixth Amendment, and a right to freedom of press, much like the First Amendment, in most European constitutions, Germany, France, Australia, Canada. But the balance there seems to be different than what's being struck in the Sheppard case. There, it's much more likely for judges and courts to impose pretty severe restrictions on what the press can even report on during a trial, if they fear it is going to prejudice the jury and or the defendant himself. So, for example, there was a trial in England in 2010. The defendant had very extremist right-wing views on certain issues. And the judge told the press, you are not allowed to report on his beliefs until the trial has been finished, because we do not want that to influence the decision making of the jury and everything else. So those types of decisions that I just found were made trial after trial, where it's kind of like the thumb is put on this the protection of the accused rights more than on the freedom of the press, much more so than we see in the United States. So again, I think that's cultural, historical, maybe gets to Chris's point about the freedom of what it means to have a free press versus what it means to have a right to know everything that's going on in a courtroom. Maybe that's distinct, but
Chris?
Well, I just wonder, and I don't know. I wonder if this is the difference between our adversarial system of justice and a more modern sense of inquisitorial. Because for the students watching, our adversarial justice system is not about finding the truth, right? It's not about finding the truth. It's to give, as an attorney, my job is to give my client the most vigorous defense I can. If that means clouding the minds of the jurors and doing whatever I can to give them the most vigorous defense. And the prosecution's job is to prove my client's guilt beyond a reasonable doubt, as opposed to more modern inquisitorial systems that we see in Europe that are about finding the truth. So I wonder if there's that difference there between our two systems of justice. I don't know. I'm just curious.
Yeah.
No, that was exactly my question. I kind of heard they're rooted in an inquisitorial system and we're not. That's kind of, I thought the same thing too, Chris.
Well, I don't know. Is that accurate, Mike? I know some centuries ago it was, but I thought most modern European countries had transitioned to more adversarial types of
they
systems.
have, but then maybe I hadn't thought about this angle, to be honest. Like I'm sure you all can see watching me. It's a really good point. I'm wondering, even if the format and the process has kind of changed where maybe adversarial, the roots are there. And I got just thinking back to Unit 1 stuff and the idea of the balance between the collective or maybe common good and individual rights. We definitely know that there's a difference between Europe and the United States on that. And maybe there's a part of that this is grounded in, even though the process has changed.
Well, the modern inquisitorial is not like the old, if you float, you're a witch kind of thing. It's it's a much more modern sense where it is about solicitors or attorneys finding the truth. And you see this in Scandinavian countries, you see it in Japan. So it's not like the old school you're guilty until you prove your innocence, that the Spanish Inquisition. It's a much more level playing field. And it goes back to, I wonder if that's, Mike talks about the systems in Europe where the thumb seems to be heavier on the rights of the accused over, the trial and a free press kind of thing. And I wonder if that's because they're more interested in finding out the truth as opposed to saying guilt or innocence.
Yeah.
Well, and I'd say, talking about the roots of our system, I mean, the adversarial system is very important, but to me, the larger principle of the system, if we read the Constitution, Chris, is to protect the rights of the accused. It's adversarial, but they're supposedly, all right, I don't know if it's ever played out this way historically, but there's supposed to be some strict guidelines on what the state can do.
Right.
And if the burden, the whole burden of proof is on the state. I don't know if it's played out that way historically, throughout, our history. But to me, that's the fundamental principle there that did divide us, is that whereas, pursuit of the truth means you don't have the right to remain silent. Right? Not an inquisitorial system. You don't have that right to remain silent because we are looking for the truth of the matter. Whereas in an adversarial system, because we want to make sure that no innocent person is falsely accused and imprisoned, all right, or falsely found guilty and imprisoned, we say, listen, there's going to be some rules here, and I guess through our discussion, it seems to me that the First Amendment, press, right of the public to know, has come to trump, at least culturally. has come to have more significance, be weighted more by judges in our society than the right to a fair trial and the burden to be put on the state and to be innocent until proven guilty. Here, I don't know. Last thoughts on that before we go to final comments?
Well, that's a wonderful pipe dream. Um, because if that was the case, we wouldn't have things like the Innocence Project, right? We
That's
wouldn't
my
have
point.
cases.
Yeah.
We wouldn't have the cases like the Scottsboro Boys. We wouldn't have a long history of people being railroaded by overzealous prosecution, or the fact that they've had a defense, public defender showing up drunk to trial or falling asleep, those types of things. So in a wonderful world of the perfect legal world, that would be great, but we know that hasn't been the case.
Well,
Yeah,
gentlemen, we've come to the end of our program here. And so as per our tradition, we have an opportunity to share our final thoughts and insights and make any recommendations we might for students and teachers dealing with Unit 5, Question 3. So Professor Williams, what are your final thoughts?
Yeah, I think I have two final thoughts. One is that, at least based on what we talked about in terms of what the court has said, it's just this balancing. So what I fear is this, dealing with this question could turn into just a bunch of hypotheticals. Well, what if this, or what if this, or what if this, right? And you're bound to maybe do that in your teams and maybe even at the hearings. I would encourage you to think about as a group what your starting principles are. You don't have to follow the Sheppard case or follow anything that we've said. What are your starting principles about these two different fundamental rights? And then let your arguments flow from that. And I would say, stick to your argument based on what your starting principles are. That'd be my first thought. My second thought is we didn't really get into the details of not only social media, but I'm thinking about misinformation and disinformation. And what happens when something just is tweeted out that is just a fabrication about somebody who is on trial. And it's not the press, it's just some person with an X account that has a lot of followers. How should our justice system deal with that and the ramifications of that? And yeah, what are the implications of that?
Professor Moore?
Yeah, wow. I'm suspicious of the press claiming that the public's right, a public trial is absolutely connected to their job. Because I think there's an argument to be made through voir dire. There is a public trial. They've tapped into people of the community. There's the public. Now, I know there's an argument that, that the press could serve a public function, but I'm tremendously suspicious. I think there's an arrogance in the press saying we're integral to what a public trial is. I think arguably we could have the public there and no media coverage, as long as the voir dire was, vetting the public. So I'm suspicious of that. And I also was taken with a thought. I actually shut my computer off for about a half hour. Hannah Arendt, she was talking about trials and the role of vengeance and all these kinds of things. And her comment was something to the effect that vengeance and the lack of well, I don't know if she didn't use the word grace, but she was really posing a tough question. And this was largely in the context of victims' rights. Everybody's noticed that there is an element of vengeance in that movement. And her comment was she's not quite sure that gets us wholeness and resolution. in some of these very, very difficult types of cases. So I would urge students maybe if you really want to get philosophical here, and this has nothing to do with legal or constitutional or anything, it's just this overall cultural comment by her about using and expecting justice to equal vengeance for these tremendously awful wrongs that have been done in society.
Professor Kavanaugh.
Tim, are you putting something in the show notes from Hannah Arendt?
Yes.
Okay, well, I just want for the students. I mean, she's an incredible scholar, writing about totalitarian governments.
Yeah.
So, if you do any study in terms of totalitarianism, you're going to run across her.
Yeah.
So, Arendt.
Yep.
So, okay. I like what Mike had to say about in terms of social media and amplifying misinformation or disinformation, which is something we barely scratched the surface of. And I like what Tim had to say about the press. I mean, they have a right to a free press, but does that mean someone has to sacrifice his or her rights for them to be able to do their jobs? So that's a really interesting question. And also understand that. The question asked about other First Amendment rights, and we focused on the press, obviously, and we focused on individuals, family members or whatnot. So, are there other First Amendment issues that may come into play that we didn't even consider? The First Amendment is such a broad thing. Are there other avenues that we didn't even touch on or we haven't even considered? I do love, actually, as a side note, I love all the Unit 5 questions because they're all setting out this tension that exists, right? These tensions in establishing, rights, and when does your right supersede my right? When does your right to, to publish a newspaper story interfere with my right to have a fair trial? So I love the tension that is set up in these questions. And I go back to reiterate what Michael said. For people on your panel, when you guys are preparing for students, know where you're going to come down on this, because you are going to get a crap ton. This is a serious term there. Crap ton of hypotheticals, some probably based on actual case law. So know where you fall before you go into this, and you may change your mind after you get into your study about these things, but then know who's playing what role on your panel, who is going to be the Clarence Darrow and who's going to be the William Jennings Bryan, so to speak. So have those roles predetermined, and then have evidence to be able to support your positions.
Well, I'm glad you said that, because that was what I was going to point out, Chris, is that there's a subtle change in this question, because the main question talks about freedom of expression during a criminal trial. And Mike, I think, and again, we didn't get to it as in depth as we should, because you're referencing, I mean, let's just be out there. You're referencing Donald Trump during his, criminal and civil procedures, using X out there to influence the society and possibly the jury, the judge, and everybody there. So it goes from the trial and freedom of expression, I'm assuming, of all people, and I appreciate it, Chris, who are involved in that, situation, jurors, lawyers, defendants, okay, how do we, people who are just watching the trial, sitting in the gallery there, kind of stuff. And then it moves on to kind of more traditional, free press and Sixth Amendment rights there. So, I think that our scholars have given you some great recommendations there, and hopefully we've helped you and provided you some insights to play around with as you prepare for this. In our next session, we're going to be jumping back to Unit 2. And reading the question, part of me chuckled a little bit, because a lot of these questions you got to read 2 or 3 times to kind of get a sense, because they do change direction. And we start out with a quote in Unit 2, Question 1, about a Federalist rhetorically asking an anti-Federalist, will a virtuous and sensible people choose villains or fools for their officers? And then at the end, it's we're dealing with executive power there. So I'm wondering about what's the connective tissue between fools and villains and executive power there. And hopefully we'll clarify and bring some enlightenment to you in our next session. Until then, peace, love, yogurt tacos. Bye-bye. Bye bonds.